Hello, everyone. Good morning, good afternoon, good evening. Welcome. Hello, Angie. Hello, Hisha. Hello, Mariano. Good to
Hello.
see you connecting on time. Thank you very much for connecting. Let's just wait a few seconds that people are still joining so we can start. Hello, Marco. Good to see you. I think we missed you yesterday. You were in the background, right? So you're not with camera on, but you were in the background. So
I arrived late.
it's
I saw
okay. It's
only
okay.
yesterday.
It's okay. It's okay. So welcome everyone. So good morning, good afternoon, good evening again. Let's get started. I think just before we start, I mean, I don't need to introduce our colleague today, Mariano Brenner. That we were with him yesterday, and we are going to continue discussing bilateral social security agreements, and now looking from where we stop and then towards the process of negotiation of bilateral social security agreements. Just a quick reminder, if you want to select your preferred language for interpretation, please select at the bottom of your Zoom application either English or Arabic. But also when our colleagues start sharing the screen, Mariano is going to be sharing the English presentation and Hisha is going to be sharing the Arabic presentation. So please make sure that you select at the top of your Zoom application your preferred presentation language. Okay, so it's time to start finally. So Mariano, thank you very much, and back to you.
Thank you very much, Elton. While I'm looking for my presentation, is there any questions? Do we have any questions from yesterday that need to be sorted out?
I see Angie nodding for no, and don't see anything in the chat for the moment, for the time being. But again, just also an additional reminder, if you have any questions, any comments, feel free to open your mic and ask for the word, for the floor. But you can also use the chat box to send your comments or your questions so we can do this facilitation and exchange with Mariano while he presents. So so far, no questions, Mariano. So I think it's all clear.
Okay, great. So we're going to be talking about the remaining of the points from yesterday, and then we're going to move into the process of negotiation of these agreements. But first, we need to discuss what legislation we will be applying. Would it be the legislation of country A? Would it be the legislation of country B? Would it be both legislations? And this is one of the things that we will normally see in these social security agreements. In principle, we will always use the law of the place where the actual work is being carried on. But this is not always the case. So this is why we would sometimes establish exceptions. These exceptions and the rules that determine this would be expressly mentioned in the agreements. And the idea is basically so that one person is not subject to two legislations at the same time. Now, this concept, as I said before, has a few exceptions. We will be mentioning these exceptions, and I will explain each one of them one by one. But basically, the exceptions to the principle of territoriality, which is the principle that you will be subject to the laws that apply to the place that you perform the work, are what we call the posted or detached workers, the seafarers and the persons working in air transportation, civil servants, the members of consular and diplomatic representations. There's also a clause sometimes in the agreements that it's a saving clause, that what they say is that basically they can agree on other exceptions if both parties are in agreement. So they determine the rules that will apply for the posted workers, the seafarers, the civil servants, the members of the consular and diplomatic representations, and they say there might be additional exemptions. And also, in some agreements, there's a specific clause for the self-employed. We will see a few of them in the next slides. So posted or detached workers, you will see them mentioned both ways. The definition, it's an employee working for an employer in a country who is assigned, so it's transferred by the employer to work in the other country for a limited period of time, usually for the same or a related employer. The typical case, the simpler case of detached worker, it's someone working for a company. Let's say the company opens a branch in another country. And because of the knowledge, the specific knowledge that this person has, they ask him or her to go for X amount of time to explain the new colleagues, the new branch that has opened, how to do the job. So for example, if there's a specific machine that they're now implementing in another country, they might ask this specific person to go and train the people for 6 months, 1 year, 2 years. And then once it's done, this person will come back to his or her home country. Now, the length, the period that this detachment can work depends on what is agreed between the parties. Sometimes the party will agree that it's only 12 months. Sometimes the parties will agree that it's 24 months. Sometimes they will agree that it's 5 years. And they can also agree that it can be for a one time only. So let's say 12 months and never again. Or it can be for an extended time. So it can be 12 months plus 12 months. Or it can be a whole 5 years all at once. It really depends on what the parties negotiate and what is the agreement and what is the interest of the parties that are negotiating. And as I was saying, the objective is basically to ensure the continuity of the working career in one country alone. So if this person is only moving for 6 months for the specific machine that we mentioned before, if he or she would have to contribute for 6 months only in a different country, he or she would have a lot of short spaces in his or her career. The idea is that this person will have a continuous career in the same country because the role that they're doing, the work that they're doing, it's only required for a short amount of time and for specific task. So basically, the person continues to contribute to his or her country of origin, and they're not subject to the social security system of the country of destination. This is one of the exceptions. Is this a clear exception? Something that I did mention yesterday and that I'm repeating today is that sometimes we will find agreements, social security agreements, that will refer to this category alone. So the agreement would be only for this. They wouldn't be talking about anything else, none of the other topics that we discussed yesterday, but they will be focusing on this thing alone. Elton, you let me know if someone raises their hands. Now, for government employees, which is another exemption that I made, there is a specific convention, the Vienna Convention on Diplomatic and Consular Relations, that sets the rules for social security coverage of diplomats and their personal staff. So what we would finally see in these agreements, in the social security agreements, is that a clause that will be saying something like for diplomatic and members of the consulates, they will be ruled by the Vienna Conventions that apply to them. Now, on a second step, the civil servants of one country that is posted to work in another country are subject to the social security system of the sending country. Okay, so the civil servants of one country that works in the embassy or the consulate of another country, their country, but in another country, they're still subject to the social security of the sending country. Another thing that we will see in these agreements is different clauses on definitions. Like with any other agreement, any other treaty, we need to have definitions. We need to have terms that we both parties agree on what they mean. The definitions that we will most likely see, we will see, I would say, in all of the agreements are what are the parties, what is the legislation, who is the competent authority, who is the competent institution, what do we understand by benefits, what do we understand by insurance period, and what do we understand by liaison bodies. In very simple, because we don't have much time, the parties are the two countries or the multiple countries that are going to be signing this agreement. The legislation, as I explained yesterday, is what legislation is going to be applied, but also what it means. The competent authority is usually the ministries, but it can be other institutions, which are the institutions that are entitled to negotiate these kinds of agreement. The competent institution would normally be the institution that actually manages the Social Security, which can or cannot be the same as the competent authority. It can be the same. It can be that the ministry, let's say in Jamaica, for example, Jamaica has the Ministry of Labor and Social Security, and the institution that actually manages the Social Security is within the ministry. Then, for example, for benefit, we would define what the benefit is, what we understand for a benefit. Insurance period, there would be a definition for that too. And the liaison bodies are the institutions that will be connecting to each other, that will be transmitting the information that we will use to communicate, basically. Then other terms are also defined, but that depends on each agreement. And it can be specific for one country or for another country. So it might be that one country has a specific term that wants to define in the agreement so that it's clear what it means. They would request that it's included in the agreement, and it would say something like, for Canada, for Argentina, for South Africa, this term will mean such and such. There's other terms that we can find. These are not necessarily always there, but some of them are very often there. And the terms can be territory, national or citizen, worker, employee, or what we understand by self-employed person, government employment, family member, dependent, survivor, residence or stay. And then, as I said before, other terms specific to each one of the parties. So far, so good?
So far, so good, Mariano. Just one comment from our colleague Azhar. When you were saying before, just an example that he was saying that there is a social security agreement between Egypt and Tunisia that exempts a worker employed for a period in a project in the other country from paying contributions in the host country.
Yeah, you will see that in many of the social security agreements, there's clauses related specifically to detached workers. And then, as I was saying also yesterday, there's the issue of the confidentiality. We will be working with information that is very private. We will be working on salaries of people, health of people, and this is information that cannot be transmitted to everybody. It has to be kept confidential. So we will see that in all of these agreements, there's going to be a clause about confidentiality of the information. So we will see something like, unless otherwise required by the national laws of a contracting party, information about an individual that is transmitted in accordance with this agreement to the competent authority or agency of that contracting party by the competent authority or agency of the other contracting party should be used, and this is the important part, exclusively for the purposes of implementing this agreement. Any information received by a competent authority or agency of a contracting party shall be governed by the national laws of that contracting party for the protection of privacy and confidentiality of personal data. What we mean by this is, first, that we have to have specific attention to the information that is being transmitted. Second, that this information cannot be transmitted to other institutions within the country. It has to be used solely for the purposes of implementing this agreement. And third, that the legislation that is going to govern how we manage the confidentiality is going to be the local legislation. Now we're going to be talking about totalization, and this is probably the most important part of the Social Security agreements. We were saying that one of the things that we would find in these kinds of agreements is the possibility of people to access benefits by adding periods to actually how can I say this? Adding periods to actually achieve the minimum required to access a benefit. So if a benefit to access a benefit of pension, we would need 10 years, and I have worked only 8 years. I could use 2 years that I've worked in a different country with whom my country has a social security agreement. So for totalization of periods of contributions of social security refers to those periods that we have worked in multiple countries and can be combined or totalized to meet the eligibility requirements for social security benefits. That was the word that didn't come, eligibility. So again, we have a requirement, a minimum requirement, and we can't arrive to this minimum requirement by the period that we work in this country alone. We could use the help of periods that we work in different countries. Always remember, formal work, not informality. And then we would use that to meet the eligibility criteria. Here you will see a little bit of a timeline that it's going to show you how we could think of the periods. We see line blue. It's the time of that I worked in country A, and line red is the time that I worked in country B. So you will see that in country A, I worked 20 years. And in country B, I worked 15 years. Is that clear? If, for example, to access the benefit to meet the eligibility criteria for country A, I need 25 years, I would normally not be able to receive the benefit because in country A, as you see in the line, in the blue line, I have only worked for 20 years. So what I would do is I would take 5 from the red line and add it. This is a simulation. This is not, it's not like I take them and put them. I just use these 5 years that I have to prove that I worked in country B. And then I meet the eligibility criteria. Now, when do we need eligibility criteria? This will depend. It can be in the long-term benefits, and this is something that we also discussed yesterday. It can be for the longer-term benefits like pension or survivors, but it can also be for shorter-term benefits. For example, maternity, for example, unemployment. There's other benefits that sometimes will require that you have contributed for a certain amount of time, maybe 3 months, 6 months, 1 year, 2 years. And it might be that you just moved to a new country. So if the agreement has within its scope this particular benefit, the legislative scope, remember that we mentioned it? If it is within the scope, I could use the years that I work in the other country, totalize them, and meet the eligibility criteria to access the benefit. So again, the totalizing, what we're looking for is to assist migrant workers to meet the requirements of a qualifying period for entitlement to benefits under social security systems of the country in which they have worked. And again, there's, like I explained just now, there's 2 types of qualifying period: a minimum period of insurance, for example, for the entitlement of old age pension. So let's say you have to have worked at least 5 years to get a proportional pension, and you have to have worked 30 years to get a full pension. And then a recent period of insurance, as I was saying before, to access other benefits like unemployment or disability or other benefits. that has to be recent, that has to be related to the present situation. So I get unemployed tomorrow. The country might have asked that I have worked and contributed for the past 6 months. Are we clear with this one? This is complicated.
I think it's quite clear. There is one question in the chat. Angie was asking if, in the case that we have a bilateral social security agreement, are periods of employment in both countries recognized automatically, or must the worker initiate the process to have these periods formally acknowledged?
We will be discussing it when we go to the process, but basically, once the person wants to access the benefit, whatever benefit it is, they will need to complete a form. In one of these forms, they will have to indicate where they worked, because the Social Security institutions don't exchange the whole information for the whole people that worked in that country with all the other institutions. So it's the very same person that has to say, in one of the forms, I work from this year to this year in country A, and from this year to this year in country B. And then what the institutions are going to be is what they're going to do is they're going to connect, and they will exchange the information to make sure that they actually have the records that show that you worked in country A and in country B for the years that you are indicating. Now, something that is important is some countries, for example, have voluntary contributions. So you can contribute even if you're not in the country. So it might be that you will see periods of contributions that overlap, like you're seeing now in the slide. So from year 15 to year 20, you see that I will have contributions in both countries. In this case, these contributions cannot be used for both. So say, for example, I have worked in country A for 20 years, and country A is asking 35 years to access the pension. I cannot take the 15 that I have in country B, because 5 of these 15 years are overlapping with years that I've already declared in country A. So I could only use 10 of the 15 years from country B, because 5 of these years are overlapping. Was that clear?
I think so, Mariano. Yes, Angie is nodding.
Okay.
So
Okay, good. So this is an example that I'm giving you so that you can better understand. We have country A and country B. Pension for 20 years, it's 1,000 in each country. That's the amount of, let's say, dollars that you would get. And the minimum years to access this benefit is in country A, 20 years, and in country B, 25 years. If we look at the work life, the work record of this person, she has 10 years worked in country A and 10 years worked in country B. We will suppose that there is an agreement between the two countries. Now, the person that has worked 10 years in A and 10 years in B, not overlapping, we're going to assume that there's no overlap in the years. They will have the 20 years that are required in country A, because they will add 10 plus 10, and that would give me 20 years. So I will access the eligibility. I will meet the eligibility criteria. Now, for the payment, what this person is going to receive, she is not going to receive a full pension because she only contributed for 10 years in country A. So what she's going to get is only the amount of years that she contributed in the country. In this example, it's very simple because she only contributed for half of the time required. So she's going to get, instead of 1,000, which was the minimum pension that we indicated, 500. Is this clear for everyone, or should I repeat it?
think it's clear, Mariano. Yeah, no
Good.
questions. There's just one
Good.
question on the how overlapping happened.
Well, it can be that you contribute, say you're working on both, or you're working, let's look at the easiest example. You're working on country A, but country B allows that you make voluntary contributions from overseas. So even though you're not working in country B, you have worked in country B, and you want to have a better pension when you retire from country B. So you continue to contribute despite not being there, and while you work in country A. Now, to meet the eligibility criteria, you will not be able to use these 2 years that are overlapping. But these years that are overlapping will count in country B when you count for the amount of the pension. Now I have a question for you. We're saying that in country B, the minimum pension is going to be 1,000, but the minimum required to access the benefit in country B is 25 years. Looking at the worker's record, will the person be able to access the benefit in country B?
Well, let's see.
If the person has worked 10 years in country A and 10 years in country B, but the minimum eligibility criteria or entitlement in country B is 25 years, will they be able to access the pension?
So Angie is saying not yet. Niha maybe not considering that even with totalization is not 25 years. Not, no.
Correct. That's correct. Now, remember that yesterday when we were starting and we were talking about the third countries that we might have, where both countries have agreement with, this could be an extension of how we use the Social Security agreement. So let's say, for example, that country A and country B have Social Security agreements with country C, and the person has worked in country C for 5 years. Again, not overlapping. So we would have now 10 in country A, 10 in country B, plus 5 in country C. Then our person here, she would have access to the pension in country B because she would be taking 10, 10, and 5. Now let's look at a different example. And here we have the pension in country A, it's 1,000, and the minimum years for entitlement are 20. The pension in country B is 600, and the minimum years for entitlement is 20 years. According to the worker's record, he, we'll talk about he this time, has worked 15 years in country A and 10 years in country B. So there's a total of 25 years. So this person meets the eligibility criteria for both country A and country B. Now, the person has worked only 15 years in country A, so the pension will be 15 out of 20 multiplied by the amount of the pension. So it's going to be 750. The pension for country B is going to be the 10 years that this person worked in country B by 20, which is the minimum years for entitlement. And then we would multiply these by 600, which is the minimum pension. So this person would be receiving 750 from country A and 300 from country B. The total would be 1,050 that this person would be receiving. As you see, the total is higher than the minimum of each of the countries separate. There's no limit to this. There's no restrictions to this. Because as we said yesterday, we will only be looking at the legislation of each country when we do the calculations. Is this clear for everybody?
Yes, so
Yes,
far.
it's clear.
Yeah, it's clear.
Good. Now, there's something that is, there's a hand raised from
There's a,
Laundry.
yes, Landry. We cannot hear you. Sorry, you don't have a sound.
You hear me now?
Yes,
Yes.
yes.
Okay, thank you. Please, I want to know about this totalization. Because you know that the way of determining salaries depends are different from one country to another. Yes, the minimum wage is different from one country to another. The rules for calculating social contributions are also different from one country to another. So I want to know, if you have to applicate this totalization, which salary which will you consider? If I take the example here in our social agreement between Cameroon and France, for example, here we have a minimum wage, which is 60,000 CFA francs. And if you have to applicate this totalization with someone who works in, one part of his career in Cameroon and another part in career in France, which salary will we consider? That's what I want to know.
Okay, so this is
know
a simple
that
question.
benefit depends on the salary the worker earned during his career.
Yeah. What you have to remember, Landry, is that the years that you take from the other country, it's a fiction. You only take them to arrive to the minimum eligibility criteria. So the salary that you will be considered is the salary of the country that you are considering. So for country A, you would only consider the salaries that the person received in country A. And for country B, you will only consider the salaries that the person received for country B. What you would take is the amount of years that you need to access the eligibility criteria. But the payment, it's only be related to what happened in each of the countries.
Okay, so if I understand well, totalization is only for eligibility criteria.
That's correct.
So it just help to know if it will help you to have to be eligible to something for old age pension, for example.
Exactly.
And for the amount of money we have to give to the beneficiary, how do you calculate it? Okay, the person is now eligible, and which amount of money you have to allocate him? How calculate him? Please, I want to know.
Well, this is on a case by case, and it really depends on the country. So each country has a different criteria to determine the base salary for the pension. So this will depend on each of the countries. What I can tell you is that once you determine the base pension, what you are going to do is you will relate that base pension to the amount of years that the person actually contributed in that specific country. So you have the eligibility criteria met, so you tick on that. But then for the actual payment, it's the local rules that will determine what is the base salary, and then is the years that the person contributed in that country that will determine the amount of the benefit.
Okay. Okay, thank you.
Okay. Now, there's some countries where there is consideration of a minimum benefit. I'll read an example. For example, I think it was Italy that has or had established that all of the people that received pensions from the agreement between Argentina and Italy would have access to at least the minimum pension. This means that there's a minimum pension determined by Italy, and everybody that received a portion of their pension from the agreement between Italy and Argentina would receive at least the minimum benefit from Italy. Now, we can also have the opposite. We can have a clause, and this is what you will find in most cases, saying that the countries do not guarantee this minimum benefit. So if we go back to the example before, the minimum benefit of country B was 600 for someone that had worked 20 years. If we take into consideration what we're saying here, the country would not guarantee that the person would have these 600 and they would only receive whatever they deserve or whatever they have the right to with relation to what we have totalized. And an example of this is the agreement between Argentina and Israel that says the parties do not guarantee to the beneficiaries of benefits calculated as described in paragraph 2, which is the totalization, the minimum income established in their legislations for beneficiaries who have completed all periods under that legislation. So as we were saying, we would use totalization, we would reach the eligibility criteria, but that would not give us access, and this is related to the question that I just had, that would not give us access to the full minimum pension. It would only give us access to the part of the pension to which we have rights, given the years that we have contributed in that country. Now, as with any agreement, there might be disputes between the countries. There might be disagreements. There might be things that are not completely defined, are not completely determined, and by the time that they have to implement them, they realize that it's not completely clear. So what the agreements would normally say is that these disagreements should be resolved by way of negotiation between the competent authorities of the contracting party. Remember, competent authorities was one of the terms that I mentioned at the beginning today that would normally be defined in the agreements. And then the other question is, how long does this agreement last? In general, these agreements would be for an indefinite period, which means that they would normally not have a date of issuance. Then the usual clauses that we will see is something like this. This agreement shall remain in force for an indefinite period. The contracting parties may, at any time, terminate this agreement by means of a written notice communicated through diplomatic channels 12 months in advance of the termination of the date. So the principle is that they last forever, but they can be terminated. For that, there has to be a process that has to be followed. And even after that process, there is another period that has to pass before the actual agreement is terminated. And something that is important, and it's the second part of this clause, is that in case of termination of this agreement, rights regarding entitlement to our payment or benefits acquired under it shall be retained. The contracting parties shall make arrangements dealing with rights in the process of being acquired. So whoever is already receiving a pension because of this agreement will not lose it. This person will continue to receive the pension. And then for the periods of time that we will need to totalize what we were saying about the rights in the process of being acquired, then the parties will need to make the necessary arrangements so that they can be used to actually reach the eligibility criteria. Any questions about this before we move to a different topic?
I see no questions.
No? Okay. So here you will see a few examples of multilateral social security agreements. In these agreements, as I mentioned before, the EU regulations on coordination of social security systems, as you see, coordination, it's in the title of the regulations. It's applied to all 27 members of the EU, as well as Iceland, Liechtenstein, Norway, and Switzerland. The Schengen that I mentioned yesterday too. And it's related to all 9 branches of Social Security. There's also another agreement in the Caribbean, the English-speaking Caribbean, plus Haiti, here in the Americas. And it's applied to 13 states, mostly in the English-speaking American Caribbean. Then the Ibero-American Multilateral Convention on Social Security, that it's applied to countries in the Americas and also countries in Europe, specifically to Portugal and Spain. And then something that was mentioned yesterday, the Inter-African Conference on Social Security Multilateral Convention, that is between 15 French-speaking countries, mainly West and Central Africa, and it's called Cyprus, and was signed in 1996 by 14 states, but has not yet been ratified by all of them. And here you have an example of the Ibero-American agreement. You will see the first line is the countries of the region involved. The second line is when they signed this agreement. The third line is the ratification, and I'm going to be referring to this one when we talk about the process. The ratification, then the fourth line is the deposit of the document in the OIS, that is the agency that is in charge of handling the agreement. Then the next line is the signature of the administrative agreement. The next line is when it actually became effective. And the last line is the population that is covered. Something that it's interesting is that we might find it's something that I didn't mention. We might find that in a multilateral agreement of, say, 10 countries, there might be a clause that says that the agreement will only become effective after 5 countries have signed it. So in this case, if we have 3 countries that have signed it, despite the fact that they have done all the necessary steps to make it effective, it will not become effective until 2 more countries sign it. So here you will see, for example, that the date of signature is different. So not all the countries signed the Ibero-American agreement at the same time. There were a whole set of countries that did. You will see, if you look at the numbers, you will see Argentina, Bolivia, Brazil, Chile, and other countries that were part of the original signature of the country. But the agreement allows for other countries to then join in. And this is the case of Honduras, which is the lower arrow, that only joined in last year. You will see also that the date of ratification and the date of deposit of the document, which is a necessary step to make it effective, is going to be different, because from the ratification, there usually is a step up to the moment when the country actually deposits the agreement. And then the deposit and the signature of the administrative arrangement can be the same, but can also be different. There's no rule on that. The date of the administrative arrangement and the agreement can be the same because they can be negotiated at the same time, but we will see that in the next part of the class. Do you have any questions about this part? With this, we end the first part of the class.
I don't see any questions so far, Mariano. So we can move to the process.
Okay, so we move to Nihal.
Nihal, yeah.
Sorry. no, my phone is going off on, and then I'm connected through both my devices because of internet issues. No, thank you, Mariano, for that overview. Because but then like nothing particularly related to the last few slides. But then I think one question that I kept having since yesterday was you've made it very clear that when we're talking about these agreements and their applicability, we're talking about those who work in the formal sector. And I think that's come up quite a bit. And we've also seen recently a lot of countries have been adopting guidelines to extend social protection to workers who also work in the informal sector. In the event that the countries who are signing these bilateral agreements, if both of them have that sort of mechanism, is coordination possible even then to expand coverage to those who work in the informal sector?
Let's see, let's get an example. If there was, for example, if there was a moratorium where the country would allow a person that worked informally for 10 years to actually pay for those 10 years, pay the contribution for those 10 years. And that would be in the records of the person. This could be part of the social security. But when the benefit is a non-contributory benefit, it would normally not be included. Did I answer to your question?
Yes, Mariano. Thank you. Thank you.
Okay, good. So we're moving to the next part, which is the process. And I like to say that we have an 8-step, a 1+8-step process. The normal 8-step process will consist on the preliminary discussions, the preparation of the initial draft agreement, the negotiations itself, the review of the agreed text, the signing of the agreement, the approving of the agreement, the conclusion of the administrative arrangement and the application forms that I mentioned before, but I'll mention again, and then the entry into force of this agreement. But before we actually do all of these, we need to decide who we will be negotiating with and why. We don't just negotiate with parties. What we do is we choose the parties that we want to negotiate with, and there's usually a reasoning why we choose these parties. Why do you think that a country would choose one country over the other to start a negotiation of this kind? Any takers for the question?
Let's see if we have
Yeah.
anything in the chat. Yes, Neha, please.
No, I guess it depends on the context, like the mobility context as well, right? I think you would want to have agreements, bilateral agreements or multilateral agreements with countries where you do have a lot of the workers flowing across the corridor, maybe. So I think that might be one of the key considerations that would be taken into account.
That is correct. What else? Anybody else? Any ideas?
Catherine is saying the number of workforce.
Then what does it mean, the number of workforce?
Catherine, over to you.
I think it's basically what Neha said. Can you hear me?
Yep.
Yes.
So basically the workforce or the number of migrant workers coming from one country to the other. So I think the quantity also plays a role as to why it should be important to have a bilateral or multilateral agreement between them.
Anybody else that has any ideas?
I see Landry.
Yes, it can also be a purpose of regional integration because recently I conduct a study for social security agreement here in ECAS. ECAS is the Economic Community of Central African States. So we are going to develop the regional community, so it can also be on consideration of such needs. Thank you.
Anybody else?
Okay, Nihal is also saying the existence of national social security mechanisms.
Yes, one would normally choose to negotiate with other systems that have a somehow developed social security system. That's correct. And then I would say there's two other main ones that we normally would find in why we start a negotiation with a country. I'll give you one. One is political. It might be that for whatever reason, the country wants to get closer to another country. So they would start negotiating different kinds of agreements. And this could be one of the agreements that is negotiated. So the Ministry of Foreign Affairs will say, I think we should start a negotiation with X country because we want to get closer to this country. And then the other reason, let's see if somebody can think of it. Otherwise, I'll just tell it to you.
I think that some other reason can be economic after political.
Yes, correct. It's the economy. There's economic reasons. We want a country to come and invest in our country. We want to have a closer financial relationship with the country. So we would sign these kinds of agreements that will facilitate the movement of persons and therefore the movement of funds to invest in one country or the other. So there can be also the financial, the economic reason that was mentioned just now. That's correct. Now, this is not reading very well. When we think about the main documents that will be part of an agreement, we think of the agreement itself, the Social Security Agreement that I mentioned before, then the administrative agreement or administrative arrangement. It can be mentioned in different ways. And then the forms. The administrative arrangement, it's a second document that, as I explained yesterday, would basically help us understand how to implement the agreement. These can be signed, that can be negotiated together with the main agreement or as a separate part. And then the other part is the forms. The forms is what the person would normally be completing when they try to access the benefit. So as it happens with all other benefits in Social Security, when you have the right to access these benefits, you would need to complete a form. Might it be online, on paper, you might go to the actual institution offices to request it, but you would need to complete a form. So this is one of the things that is also negotiated between the parties because they have to agree on a form that they will both use. It doesn't mean that it has to be the same, but a form that they will both use and understand to implement this agreement. So we say, okay, we have a new social protection agreement that has been signed. Now what? What do we do? We start with the administrative arrangement. And what does it cover? The administrative arrangement is basically a subsidiary document, an annex that explains how all of the procedures are put in place. Something that is important is that, as I said, it can be called administrative arrangement, administrative agreement. It can also be called protocol. It really depends on the countries that are negotiating. The administrative arrangement is going to complement the administrative agreement. And we will be needing this agreement in order to actually enforce the main Social Security agreement, because it is going to be here that a lot of the things are going to be explained. This is why I was saying just now that oftentimes we will have it negotiated all together, administrative agreement and administrative arrangement, or one after the other, but they will not be enforced or they will not be able to implement it until these, and the forms are already agreed. So who negotiates and signs the administrative arrangements? Is it the same team that negotiates the agreement? What do you think?
I think no,
And why not?
because the negotiations are made by some expert and people, functional and manager of the ministry, and the sign is always political.
Okay, that's partly right. It can be that it's the same team because oftentimes the teams are composed not only of the persons of the ministry, but of other people from the institutions that actually apply the legislation, from the Ministry of Foreign Affairs. So it might be that it is the same team that negotiates both. They can, as I was saying before, they can actually be negotiated, I wouldn't say at the same time, but one immediately after the other. Does the same person that signed the agreement always sign the arrangement? No, it's not always the same person. It can be, but because of the nature of the administrative arrangement, it can be that it's a different person. Why? Because for the administrative agreement, the process is going to be that once it's signed by the Minister of Foreign Affairs or the President or by someone that has been granted the power to sign this by the nation, the agreement will go to the Congress to be approved. The administrative arrangement doesn't follow that because the administrative arrangement only explains how the agreement is going to be implemented. So we would say that it's more flexible. Therefore, the person that signs it might be, for example, the Minister of Labor. Yes, Laundry.
Yes, please. As far as administrative arrangements are concerned, I want to say that it depends on, it depends. In some arrangements, administrative, in some agreement, please, in some agreements, administrative arrangements are part of the agreement. So in such case, the one who signed the agreement, because signing the agreement is also as you sign the administrative arrangement. So I wanted to put out the fact that it depends. Such cases, arrangement is part of the agreement. So we sign both at the same time. Okay.
Yes, you can sign it at the same time. You can sign it at a different time because normally the agreement goes to the Congress and the arrangement doesn't. What often happens is that while the agreement is following the process, the legal process within each country to be approved, the teams continue to negotiate the agreement. It might be, as I said before, that there's time within the negotiation rounds and the parties decide that they want to negotiate all together and take advantage of the fact that they are already meeting. And then all documents are agreed at that time, or it can be different. It really depends on each negotiation. Each negotiation is unique. So we cannot say this is the rule that will guide all negotiation. It will depend on the countries, it will depend on the interest, it will depend on the social security systems, it will depend on the internal structures that they need to actually approve these agreements. So it will vary. If we look at the over 600 that I mentioned yesterday, we will find a lot of different ways. So what you need to find out is the way that it's done in your country. And if you eventually have to negotiate with someone else, you need to find out the way that these countries are going to do it too. Something that I didn't mention is that if I go back to here, in the first round of negotiations, the point number 3, we will have a first day of the meeting where each of the countries will explain their own social security systems and their own process of approval of these kinds of agreements. So there will be a clear understanding on what is the social security of each of the parties, and then what is the process that will be followed once the agreement has been agreed upon. Now, is there a standard structure for the arrangement? As I was saying, no, it can be called different ways and it can be drafted in different ways. There is one standard structure that it's a model from the ILO for the agreement. That doesn't mean that has to be followed exactly, but it's a standard model that's under one of the conventions. But for the arrangement, there's no such thing. It will depend on what is negotiated because of each agreement being different. The arrangement that will then help implement this agreement is going to be different. Then does the arrangement follow the same approval process as the agreement? As I said before, it can be that it does, it can be that it doesn't. I can give you examples from my own experience. In Argentina, one of our agreements, the Mercosur agreement, which is a regional agreement, the agreement and the administrative arrangement went together to the Congress for approval. But there's many other agreements where only the agreement went for Congress approval and the arrangement followed a completely different process. Then the next question would be, is there always one arrangement for every agreement? No, it can be, as I said before, that there's an arrangement and a protocol, an arrangement and some other document. It really will be based on the experience of the negotiation teams and the history of negotiation. And this is one of the things that you would normally do when you're negotiating an agreement. You would do a little bit of a research on who you're negotiating with, what agreements has this country signed, how have been the negotiation process between this country and the other countries. And this will give you a little bit of information on what to expect when you start a negotiation with someone. Now, as I was telling you before, everything is done. We have already agreed in the Social Security Agreement. We have already agreed on the Social Security Administrative Arrangement. And now, how does this actually becomes a right for the people? How do they access these benefits? Because now it's very nicely written. Everything is approved, but we have to be able to reach the population somehow so that they can actually access these benefits. And for that, we will use the forms. What kind of forms? It will depend. It would depend firstly on what are the rights, what are the benefits that are included in this Social Security Agreement, but also it will depend on how bureaucratic the countries are. I can give you an example. With the Social Security Agreement with France, if I'm not incorrect, I think we had Argentina and France had, I think it was 9 or 10 forms, and other Social Security agreements only have 5. And why? Because some of the forms will be used with the public, and some of the forms that are negotiated will be used between the agencies to exchange information. And then it might be that one form contains a whole bunch of information at once, or it can be that there's multiple forms that will contain separate bunches of information. These will also depend on each negotiation. And then what information should they contain? Well, it will really depend on what kind of benefit they are related to. If they are related to, for example, a detachment, we would need to know how long the person is moving for. We would need to probably know the history of this person in the country of origin. We would need to know information on the company that is requesting this. So it will really depend on what is the actual benefit or the actual part of the agreement that we want to benefit from is the information that these forms will contain. And as I said before, this information will normally be confidential because we'll be talking about information that is salaries or health of the person or the composition of their families. And this is not information that you can share freely with people, and you cannot even share it with other agencies unless required by a judge. So you would, that's another thing that you would normally see in the agreements. there will be one clause that would say something like, if this information should not be shared unless required by a judge, and that this situation has to be communicated to the other country so they are informed that this information is being shared. The next question is, can we use a standard form? We could, but it's not usually the case, because each social security agency in each country will have their own requirements of informations, their own requirements of the forms that they need. So we cannot normally use one form for multiple agreements. And this is, remember yesterday when I was talking about the bureaucracy being a lot more simple in a multilateral agreement than in a bilateral agreement? This is exactly why. If we have, let's say, 10 bilateral agreements with 10 different countries, we would normally have 10 sets of forms that will relate to each of these agreements. On the other hand, if we had one multilateral agreement with all of these countries, we would normally have one set of forms that will be used to benefit from this agreement. So the process would be much simpler when we're doing a regional social security agreement than if we have multiple bilateral social security agreements. And then the other question is, how should the information be exchanged? So in the past, and for many, many years, we would normally have people fill in paper forms, come to the agencies, show documentation, then the agencies would validate all of these documents. They would sign and seal the forms, and they would send it by courier to the other country. That was a very lengthy process that took a lot of time. Oftentimes, the documentation got lost in the way, so it didn't arrive where it should have. Or other times, there were mistakes in the forms or in the information. So for each time, the information had to go to the other country, come back from the other country, go to the other country, and this is by post. So even if the agencies were very advanced and very quick in granting a benefit, because there would be information that would be needed that they didn't have, and they would have to wait from the other parties, granting a benefit under one of these social security agreements would take a very long time. Luckily, we have the internet. And at the beginning, the institutions would exchange these forms by mail. Now, the problem with mail is that it's not very confidential. So eventually, this has developed, and now some institutions, some countries in these agreements have developed different programs that they would use to exchange this information in an encrypted way. So it would be secured, it would be fast, and it would be very easy to trace. And should there be any mistakes, any errors, anything that is not clear, this can be discussed very quickly. Now, this is not applied widely. Not all the countries that have social security agreements have applied that. And this is one of the things that we're working at ESA. What we're trying to do at ESA is to develop an open source method that would allow countries to exchange information between them in an easy way, fast way, and not an expensive way. Because oftentimes, countries have developed platforms to exchange this information, but you have to maintain the platform. There has to be updates, there has to be security, there has to be host, and this becomes expensive sometimes. And then countries don't want to pay, and then they stop using these platforms and then go back to using paper, which is, again, takes a long time, gets lost, and so on. So there's, again, not one specific way. There's not an established method. There's not a program that everybody uses. It will depend. And once again, if we had a regional or a multilateral social security agreement, we would have one way to exchange the information between all these countries that are members to the agreements. If we have multiple bilateral ones, we might have multiple platforms that we will need to use for each one of these agreements. And what are the most commonly used forms? There's the most common one is going to be the benefit request, the one that we will be using when we want to access a benefit. Might it be invalidity, old age, survivors? We would normally need to fill a form informing what periods that we have contributed in each country, the composition of our family, our address, our social security numbers in the country of origin and the country of destination, and different information that will be required depending on what each of the countries request to their nationals on a normal benefit request of someone that has contributed all of his or her periods in one country. Now, what we would try to do is to agree between the parties to have a common form. So it would be a form that will be translated into both languages, say English or Spanish, or French and English, or French and Spanish. But the process gets trickier when we have other languages that are not so common, and we can't find people that know these languages within the Social Security institutions. So, for example, I remember when we negotiated the agreement with Korea, the forms were trilingual because we would have it in Spanish and Korean, but we would also have it in English. So all of the spaces that needed to be completed were in 3 languages. Then we realized that this became very complicated, very long, and very difficult to read. So in the end, we decided to divide the forms, and there was one form for Korea and one form from Argentina that would be exchanged, and they were simpler and in only 2 languages. Now, the other form that we would finally find is the credited periods. You could ask under most Social Security agreements the institutions to indicate how many years or how many periods have you worked in each of the countries. So you would go to the Social Security institution and complete this form and ask for information on how many years one has credited in one of the countries and on the other of the countries. The other form that I mentioned just now is the detachment form. If a company was deciding to move someone for a short period of time to another country, they would need to complete this form and indicate that what the person does, maybe the social security number of the person, of the company, where the person is moving to, the address of the company that is moving to, the social security number of the company that is moving to. So all of this information that would make possible for the other institution to identify this person and to do some sort of a follow-up. Something that I didn't mention when I was talking about the Social Security agreements is that sometimes some agreements will also allow for a detachment of self-employed. This is not the most common thing that you will find, but you will find in some agreements that self-employed can also be detached. So if a person that is self-employed, it's a consultant, could move to another country for an X amount of months to perform a specific job and then come back, but continue to contribute in the country of origin and not in the country of destination. And then, as I said before, some of the agreements would allow for one period of detachment, and some others would allow for an extension. So if the initial period was 12 months, and then we realized that we needed more time to train the people in the company that the trainer was going to, we would normally ask for an extension. This is, again, a standard form that we will find where we would have to probably use again the similar information to what we use with the detachment form, plus a reason why we need to extend these. And then the other important report, the other important form is the medical report. And this is for the case of invalidity. We would need to know a lot of medical information on what is the invalidity, what is the status, how is the person doing, if he or she requires any specific treatment. So there would be a lot of information that will be shared. And this is, I can tell you by personal experience, one of the most difficult ones to negotiate, especially because I'm not a doctor. So we would have to bring in people from the institution that specifies in this part of medical report to help us with the negotiation process. Is there any question so far?
No questions, just 2 comments from Azhar that I'm just replying here so everyone can see that in English as well. So the last one was there are communication templates in some agreements for the exchange of information between the implementing authorities to inquire about any matters related to the international agreement.
There's usually a clause in the agreements that will say that if there's any changes in the legislation, it has to be communicated. But there is not a specific form that will show how this has to be communicated. What we might find in some of the agreements, it's a form to exchange statistics. So it's a form that would allow each of the institutions to know what's happening in the other one. So how many benefits have been granted using the agreement, maybe the average amount that is being paid, information like this that can be shared between the countries. And this would be only for statistical reasons. And the second question, Elton, the second comment?
The second comment was a bit before, just saying experiences in each country differ according to the administrative, legislative, and executive aspects in each country, which vary from one country to the other. It's just a general comment on the application.
Okay, great. So let's move to the next slide. And this is about money, and money makes the world go round. Payments abroad. In which currency? So let's say someone is benefiting from a social security agreement and receives a pension from country A and country B, but he or she lives in country B now. So country A has to send the money to country B to pay for the benefit. In which currency are these payments made? Usually the payment is being done in the currency of the country that is paying. So the country of origin, country A, would pay in their own currency, and then they will send this money and the money would be converted. Now, who supports the bank transfer cost? Who pays for this? It will depend. Some agreements will say that the institution has to pay for the cost of transferring this money. Some other agreements will say that it's the beneficiary that has to pay for the cost of transferring this money. What is the problem? That in some countries, transferring money is very expensive. And depending on the amount of the benefit, it might be that the cost of transferring is as much or almost as much as the benefit itself. So then this becomes very tricky. The tendency is to try to get the institutions to pay for the transfer costs. Are there any fiscal taxes that can apply? As I was saying with the equality principle, quality of treatment principle, the taxes that will apply to the persons benefiting from one agreement will be the same as the ones that would apply to someone that has received a full pension and has moved to a third country. Now, when the two parties that are negotiating negotiate, they can also say that in each of the parties, that the receivement of the benefit is going to be considered as it was received in each of the parties. So we can say that any payment made in country A will be considered as if it was also made in country B. So the taxes that will apply will be the same that would normally apply to those receiving the benefit in country B. Is that clear? I see no questions.
Yes.
Okay. Now, something that is very interesting and is something that is not discussed as often is the recovery of the wrongly paid benefits. It might be that the institution makes a wrong payment because there's a mistake in the account number. It can be that the wrong payment is due to the person being deceased and the institution continues to pay the benefit. There might be many reasons why one institution could make an error when paying a benefit abroad. Now, the problem is that when you pay a benefit abroad, recovering it is not that easy. It's actually quite expensive, quite complicated, and quite lengthy. So what we would normally find is that when it's very small amounts, they will not pursue it. But if it's a bigger amount, they will request the assistance of the other institution, of the institution of the country where the wrong payment was made, to try to recover that money. And there's very large amounts of money that we see that is being transferred from one country to the other to pay for social security benefits. And there's quite a lot of money that is also wrongly paid. This, again, is very difficult to recover. So institutions start to be very, very careful when sending money abroad. And for example, they try to implement measures to determine whether or not a person is still alive. And they would ask for what they call a proof of life. Then this proof of life can be requested every 3 months, every 6 months, every 12 months. And it would be requested to all beneficiaries that are living outside of the country. Even sometimes institutions would ask it for the beneficiaries that also live within the country. But this is, for the most case, required for beneficiaries living outside of the country. And the way this is done, it depends. It can be that the person has to go to the embassy and present themselves and say, I'm still alive, and then they would issue a certificate that has to be transmitted to the institutions. It might be that they can do it online through different ways, web platform where they have to complete information or they have to take a photo with biometrics. And lately, Social Security institutions have also developed apps that people can download on their phones to do these proofs of lives. Now, again, the levels of development of these is very different in each of the countries. So there's not a standard on how this has to be done. The most modern ones are using biometric. And the amount of times that this is requested, it really depends. It can be, as I said, anywhere from 3 months to every 2 years. Now, the good thing about having a web platform or an app is that before, when one had to go to the consulate on the embassy, that made it very difficult for people living in remote areas, for example, or people living in cities where there were no embassies or consulates of the country. They would have to move and spend money, and they would have to be healthy enough to go to the capital of the city, to the capital of the country, where they would find the embassy or the consulate to prove that they're still alive. So as this is evolving, it's also facilitating the beneficiaries the process of proving that they are still alive. And then this is something that I already mentioned, whether it has to be paper or electronic exchange. Each bilateral agreement decides how they're going to do it. For the most part, they're doing it electronic, or they're trying to do it electronic. In multilateral agreements, we would use one set of forms for all of them. In bilateral agreements, there would be different forms. And as I told you before, the ESA is trying to develop a new concept, a new way to exchange information that will facilitate this process between 2 or multiple institutions. And then data exchange or civil status and death. This is what I told you before related to the payment and the recovery of the benefits. Normally, we would need to know if the person is still alive. But then oftentimes benefits can change depending on civil status. So if the person gets married, that benefit can change. If the person is living in partnership, can change. If there's a divorce, if there's children, there's different things that can have an impact on the amount of the benefit or in the benefit itself. So it's important that this information is also being exchanged. How does a country know? It should inform, well, it's something that is agreed between the parties. What they're trying to do is to automate it. But then again, it's not as simple because there's a lot of information that has to be transmitted. There's a lot of cases. And this is information that the institutions not always know that they need to transmit, because unless the beneficiary has informed that he or she has also worked in a different country, the institution will not know that they need to inform these. And then the other thing that we were saying when we were talking about the forms, and there was a question on what other forms are used, is the one that could be used for this, for the exchange of statistics. This is an yearly exchange on payments, on benefit granted or denied, on amounts paid, on the time that it's taken to grant the benefits. So this is all information that we would normally exchange just to know how the system, how the actual agreement is working. And this is a little bit of further reading that I have prepared that you will have access to, that we have worked in the ISA alone or together with ILO or different agencies, that will give you some more information on bilateral agreements, on how to protect migrant workers, refugees, and their families. So if you have any questions, any doubts, or you are interested and want to read more information about all of this, these would be the main sources where you will find the information. And should you need to access any of them and can't, you can contact me and I will be happy to assist you with this. So in conclusion, and just on time, based on the negotiation between two countries with a different social security system, every agreement is unique. The administrative agreement will help the institutions to know how to apply the convention, but there might remain gray areas. Remember that we discussed what happens when there's a gray area on the implementation. The agreement will lead to the need of good collaboration between the institutions because there's going to be information that will need to be exchanged. And then electronic data exchange is used to improve the efficiency and the reliability of these agreements. Any questions before we close?
Let's see. Thank you very much, Mariano. I see Niha has a question, but just one comment on the sources that you were showing 2 slides before. It's very interesting to see the one on the bottom right on the innovation standards and tools for international data exchange. I mean, this is probably something that is it's increasing all over the world in places where you have already some advanced social security systems. To have this exchange of information between 2 countries, especially when you have some bilateral social security agreements signed, so between the signatory countries, that speed up the process of getting data information from one country to the other and having this cross-check information, right?
Yeah. Exactly. It's one of the things that more and more we're seeing, and we're getting more and more requests from the institutions to help them find ways to exchange the information that is secure, that it's fast, that is efficient. So that's what we're working on.
Excellent. Niha.
You took my question, Elton.
Oh, sorry. Sorry about that.
No, because I think I was building on the webinar that we had last week on the digitization of recruitment practices to support protection of migrant workers. Like on one hand, we understand that it makes life easier and it also makes processes more efficient. But then Like from what you've listed, Mariano, there's a exchange of a whole list of very sensitive information and for a very prolonged period of time as well. It's not just one-off or within like a few, just within a recruitment cycle or an employment cycle, but then it's going to go on for lifelong. So what are the measures that have been taken to really protect the data was something that I was also thinking about. So yeah.
For the most part, as things move on and develop, what there always is going to be involved is the encryption of the information. And then the agreements can also indicate that, or even the local laws will indicate that after a certain amount of years that the information has been used, it has to be destroyed.
Okay, Mariano, just on this topic again, I'm just wondering whether we have already some examples on when the contracted parties are signing the bilateral social security agreements using blockchain, or
Not yet. It's going there. The idea is that it will eventually evolve into blockchain, but it's expensive to develop. It's complicated to develop, and to be quite honest, social security institutions have a lot of other more pressing things to work on, and that's why they have not invested in this yet. And that is why we're also trying to help them to develop something that will be open sourced and easy to use in the meantime until blockchain arrives.
Okay. Excellent. Very interesting. Any questions or final comments before we close for the day? No? Okay. So, Mariano, once again, thank you very much for being with us in these 2 sessions. It was very interesting. I mean, it's a very extensive topic that we could have a whole training on bilateral social security agreements. So, thank you very much for these 2 sessions. It's something that it's already, I mean, let's say a little flavor for everyone to go deep and dig on the topic, and whoever is involved in the negotiation or in consultation or even in the developing of bilateral social security agreements, I'm sure that was very helpful to start conversations at the national context. So thank you very much, Mariano. Thank you, everyone. We meet again next week for our next webinar, and hope to see all of you online.
Great. Thank you very much.
Thank you. Bye-bye.